People of the State of Michigan versus Mark 237411SM. Mr. Pierce this afternoon. Can you hear me?
I'm Melvin.
You said Mark.
Mark, did I say Mark? Whoops. I'm sorry, Mr. Melvin.
Okay.
Your brother is in the courtroom. That was a slip. Mr. Mark is in the courtroom, and I just am reading the letters of guardianship here in front of me. That's why I said that. All right.
Okay.
In regard to the matter, Mr. Melvin is present via Zoom from the Dickinson County Jail. In regard to the matter, the prosecution is here through Chief Assistant Prosecutor Kristen Cass. Mr. Coular's attorney is Nancy Schaub, who is present here in the courtroom. Concerning Mr. Melvin Coular, then I've been presented with letters of guardianship. They appear to be limited guardianship papers concerning medical and healthcare decisions, nothing in respect to criminal proceedings. Would you agree then, Ms. Schaub?
I didn't read them, so I assumed they were full guardianship. But
No, it says they are limited guardianship paperwork, and it says here limited to make medical and healthcare decisions and to receive information from and communicate with providers to make residential placement decisions.
okay.
All right, so Mr. Coular, as far as I'm concerned, unless it involves one of those issues, as far as a potential resolution of your case, you are in charge and at the helm of your criminal case along with your attorney here. All right?
Okay.
All right. So we are set today for a show cause hearing concerning the bond violation. Where are we at with that, Ms. Schaub?
Your Honor, with regard to that,
I'm sent for sentencing tomorrow.
yeah, he pled to the bond violation. We're here for the failure to appear.
I'm sorry.
3.
All right, he failed to appear for arraignment on 5/3/23 at 8 a.m. Are we ready to proceed, Ms. Cass?
Yes, Your Honor.
Ms. Schaub?
Yes, Your Honor.
Anything of a preliminary nature from either of you, Ms. Cass?
No, Your Honor.
Ms. Schaub?
No, Your Honor.
All right, go ahead, Ms. Cass.
Your Honor, the people respectfully request the court state judicial notice of its own file that the defendant failed to appear for prior court proceeding.
All right, in regard to the matter then, I am looking at the court's file. There is a citation received from Officer Petcher from the Iron Mountain Police Department. It was issued on April 21st of 2023 to Mr. Melvin Daniel Jr., requiring his presence in court on May 3rd, 2023 at 8 a.m. for arraignment. On May 3rd, 2023 for arraignment, he failed to appear. Court issued a show cause why he shouldn't be held in contempt for his failure to appear on May the 3rd. In regard to the matter, then, is there anything else you wish the court to supplement the record with?
Thanks.
Ms. Schaub, anything else you wish to supplement the record with?
Yes, Your Honor. I would call Mark to the stand.
Mark, to the stand, please. Would you raise your right hand to be sworn as a witness, please?
Do you solemnly swear or affirm that the testimony you shall give will be the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury?
Yes.
Please be seated. These are not amplifiers, so keep your voice up. They're just recording devices. Please state your name and spell your name for the record.
Mark. M-A-R-K, last name.
Go ahead.
Mr. Coular, you're Melvin Coular's brother, is that correct?
Correct.
And you also have guardianship of him?
I do. I thought full guardianship. He's about 95% brain dead.
Okay.
I mean, he died for 35 minutes. So.
And when you went to court to get guardianship, did the court determine that your brother was unable to make decisions on his own behalf?
Absolutely.
Okay. Has he incurred some significant trauma that affects his ability to make decisions and to recall events?
Yes, ma'am.
Okay. Did your brother give you the ticket that he received, the appearance ticket he received to come to court?
No, he didn't. but I should have known.
Okay, and why should you have known?
Because he would have no idea the date that he was supposed to be there. Absolutely no idea. I mean, within 10 minutes of him being home, he didn't even remember being arrested.
So your brother has no long-term memory.
None.
Okay, he can remember things for how long, would you say?
He can remember alcohol for, all his whole life, unfortunately. He remembers where Super One is, but I don't know how he gets back. The fire department finds one in the middle of the street all the
Okay,
time.
so he has lost his way home before.
Tons of times. He's walked into people's homes, slept in cars.
Okay, and he's been found to have limited competency by the probate court, is that correct?
Absolutely.
Have his doctors made any recommendations with regard to his living circumstances and his competence?
Yeah, I had him in a nursing home for a while when his weight was down like it is now. And I took him out when his weight was up because my father was still alive. And the doctor at the time wasn't happy I took him out of the nursing home, but since has retired. So his new doctor has submitted paperwork to, I wish I could remember her name, but Bellin, she's like a caseworker there. And the state of Michigan is involved because he is told to call the police and told them not to keep him hostage, I throw him downstairs, all this. So I got UPCAP, I got Bellin, and I got the state of Michigan adult
Protective services?
Protective Services involved. She's actually a really nice lady, and she's really kind of doesn't understand why he's in here right now. But they're trying hard to find him a 24/7 facility, and they can't find him one at all.
So you believe that he needs restrictive care?
100%.
Okay, and you've been unable to find a facility to place him in at this point?
80 nursing homes, none will take him.
Do you believe that he would be able to read a ticket, understand that he had a court date, and be able to come to court on his own behalf?
Tough one. I'm gonna say read the ticket, not so much. Read it to him. I have very bad eyesight, but I would say no. I would say no.
Okay, and he recently violated the terms of his bond by drinking again. Do you believe that he has the ability to follow the terms of the bond on his own?
I'm the one that got him arrested. I actually was told by a facility to call 911 when he's intoxicated, and they have to find him help. And it backfired on me.
Okay,
The police came out of my house with my brother, who didn't leave the facility, in handcuffs. And yes, he will follow the rules. And I haven't bailed him out yet because he needed some time to realize the rules, and I think his time's up.
okay, so do you think he can remember not to drink?
I will help him with that.
Okay, but independently, do you think he has that ability?
I really don't, honestly, I really don't know. I don't know. I would like to say yes, but then there comes the ticket thing. If I said yes to that, then I'd be saying yes to that. So
Okay,
I don't think do I honestly think he's gonna follow the rules? Absolutely not. I think he's honestly, sorry, Ro, but he'll do it again.
okay.
I'm,
Do you think he realizes that there are restrictions against his drinking?
I sure hope so.
Okay, I have no further questions.
Do you have any cross-examination, Ms. Cass?
No, Your Honor.
I had this marked. I'm going to show you defendant, do you mind if I mark this as an
No,
exhibit?
Your Honor, I would have.
Do you have a problem with that, Ms. Cass? It's the guardianship paperwork.
No objection.
Do you want to see it?
Do you have a copy?
No, I don't.
Just if I could, just so I know what's going on, Your Honor. Thank you. If I approach.
All right, without objection, I'll receive defendant's exhibit A. Mr. Coulard, Mark Coulard. Looks like Judge Slagle issued this July 29th of last summer.
correct.
Did you have a hearing last summer or is that an ongoing
Every year.
every year? So how long have you been his limited guardian, would you say?
About 3 years.
And what was the nature of your brother's? Did he have a specific injury?
He got hit with hepatitis A, and you're absolutely not allowed to drink on hepatitis A. And your liver's not working. Well, we got him to quit drinking. Well, he thought he was healed, I guess, on his own. His wife was still around with him. He has a wife for 29 years that left him. And he drank, and he called into work, said, Mark, I'm not feeling good. Went to the hospital, had a seizure, and dropped dead. They spent 35 minutes and 11 shocks bringing him back to life.
Okay.
They kept him in a coma, flew him to Green Bay. He actually literally was trying to break out of a window with a spoon. I mean, it's been a long process for him to be this amazing person that he is today.
All right. So bottom line is, you knew he got arrested. He told you he got arrested. And then he just didn't come back to court because you didn't help him with it.
Correct.
All right. I don't have anything else. Do you have any questions, Ms. Shaw?
No, Your Honor.
How about you, Ms. Cass?
No, Your Honor.
You can step down, Mr. Clark. Any other witnesses or evidence, Ms. Shaw?
No, Your Honor.
You rest?
Yes.
All right. Any kind of rebuttal?
No, Your Honor.
All right. Any argument?
Your Honor, we'd argue that it's been proven beyond a reasonable doubt that he has failed to appear, and then the mitigating circumstances will lead to the court how you want to handle those.
Ms. Shaw?
Thank you, Your Honor. Obviously, he failed to appear, but his competency is in question. I don't know if he's sufficiently competent to be able to perform the task of coming to court when he gets a ticket with an appearance date and time on it. He's been found lacking competency to the extent that the probate court has appointed a limited guardianship to assist in making decisions with regard to medical and living circumstances. So I would ask the court to find him not guilty because he does not have the requisite intent to commit contempt of court.
All right. Well, the guardianship clearly states it's limited. And I read it onto the record in respect to medical. He's charged with retail fraud in the 3rd degree for stealing a bottle of Southern Comfort. He was given a citation. The presumption is of competency. He's not been shown to be incompetent. He did fail to appear. I am finding that the prosecution has proven that he failed to appear and that he did so after having received proper notice. And I'm going to find that beyond a reasonable doubt. However, I will hold that and consider purging it at the end of the case, Mr. Coulard, if you continue to make your court appearances. So it's really going to be up to you. If you make them and you come to court, then I'll dismiss it at the end. But I'm going to set sentencing on the failure to appear to run with the trial date, which is presently in September 9/1. Tomorrow is the bond violation sentencing. I'm going to keep that as set.
I'm not representing him on that.
You're not.
Pled at arraignment and apparently did not request attorney to represent him at that.
All right, well, we'll sentence him on that tomorrow. I'll hold the failure to appear out there with Ms. Schaub's case. We'll see how he does on it. I'm writing in my file, consider purging. So that the proverbial ball is in your court, Mr. Melvin. Do you understand that as far as whether or not I'm going to purge that? If you make the rest of your court appearances, I'll dismiss it. All right?
Okay,
All right, so you stay in touch with your lawyer, but I'm going to see you tomorrow morning, first thing, sometime earlier in the morning for your sentencing hearing on the bond violation. All right?
okay.
All right, anything else on this file today then, Ms. Schaub?
No, Your Honor.
Ms. Cass?
No, Your Honor.
Any questions, Mr.?
No,
All right, then we'll see you in the morning. Thank you. All right, Mr. Good morning. Can you hear me all right?
yes, I can.
People of the state of Michigan versus Melvin Daniel Coulard Jr., 237411 SM. Mr. Coulard appears from the Dickinson County Jail. He is not represented by counsel this morning. The prosecution is not here of their own choosing. We are set today for a sentencing on a bond violation. Mr. Coulard, are you choosing to proceed without a lawyer this morning?
I am.
Has anybody promised you anything in order to get you to give up your right to a lawyer?
No,
Has anybody forced you or coerced you in any way to get you to give up your right to a lawyer?
no,
Does anybody tell you the court to be more lenient with you if you gave up your right to a lawyer?
no,
Are you giving up your right to a lawyer freely, voluntarily, and understandingly?
yes,
All right, for the record, I'll find Mr. has given up his right to a lawyer here today freely, voluntarily, and understandingly. I'll accept the waiver. Mr. Coulard, the recommendation is for 30 days in jail on the bond violation with credit for 20 days that you've already sat. Is there anything you'd like to say?
no,
All right, that's what I'm going to impose then on the bond violation, 30 days in jail, credit for 20 days served. The sheriff will compute your out date based on any good time that you're going to receive there. These are your appellate rights. An appeal to circuit court may be taken within 21 days from the date of your sentence or as permitted pursuant to Michigan Court Rule 6.65B. If the sentence includes incarceration, and if you wish to file an appeal but are financially unable to retain a lawyer on appeal, the Michigan Indigent Defense Commission will appoint a lawyer for you on appeal if you make that request within 14 days after your sentencing. Do you understand that advisal then, Mr. Coulard?
I do.
All right, you'll receive that in writing. Make sure you stay in touch with your lawyer. We have a trial date coming up on September 1st, right before the Labor Day weekend. Your bond conditions remain in place in the meantime. Any questions?
No,
All right, make sure you get back to court, Mr. Coulard.
okay.
All right, thank you. Thank you to the jail for your cooperation. Have a good day.
You too.
We'll be off the record.